Hey, good morning and welcome to Employment Hour in 30. I'm John Scholes alongside Lior Samfiru, who owns the Samfiru Tumarkin law firm here in Toronto. This show we talk about employment rights and severance and dismissals and your boss. Maybe you are the boss. A ton of stuff we talk about each weekend morning here, so we'll get right into it. We always start our show, Lior. Well, I know you're going to talk a little bit about what we do in the show every week, but the week that was is a huge thing. These are cases that have come across your desk and you are currently working on or have you worked on in the past. And it's of some interest to those who watch the show every weekend, right?
It is, and every week, John, I get people calling me or emailing me that's seen the show, that learned something and they want to ask follow-up questions. Maybe it triggered something in them, reminded them of their situation, which is great. So if you're watching us right now and what we're going to talk about in terms of employment law, workplace rights, reminds you of something or makes you realize that you have certain rights, certain entitlements, that's great. That's why we're here. Call me. Let's talk about that. Let's make sure that you know what you're owed, what your rights are. You know, workplace rights are important. We all spend so much time at work. We spend more time at work than we spend with our families. We spend more time at work than we spend on vacation or doing our hobbies. So we need to know what our rights are, and this is what the show is all about. And I always like to start off with a case that came across my desk over the past few days because I think there's important lessons to be learned there for our viewers. So the first, the case I'll talk to you about, John, involves a lady who called me in a very difficult situation. She had worked for a company as a bookkeeper for many years, over 20 years. And unfortunately, about a year and a half ago, was diagnosed with cancer. And obviously, that's a terrible disease. And she had to go off work for some treatment. And things were pretty rough for a while. And it was touch and go in terms of, is she even going to survive? But luckily, after going through several rounds of chemotherapy, she did get better. And she was actually cleared to return to work about a year and a half after she got off. So when she contacted her company, very excited, saying, finally, after all this time, I'm cleared to come back to work. I can't wait to go back. The company essentially looked at her like she was crazy. Said, well, you've been gone for a year and a half. You don't work here anymore. We haven't even heard from you for all this time. As far as we're concerned, this relationship ended months and months ago. And she was distraught by that, as anyone would be, and she called me, and she wanted to know what her rights are. Can she be off for a year and a half to recover from cancer in this situation? Well, here's the answer, John. Clearly, she's still an employee in the eyes of the law. She can be off as long as it takes to get off work to get better. Doesn't matter if it's a week, a month, a year, or longer. You can be off as long as you need to, as long as there's a legitimate medical reason. In this case, clearly was legitimate. Now, the company can't say that they didn't know what's happening with her. They knew she had cancer. They knew she was diagnosed with cancer. If they had questions about her status, about her recovery, they could have asked those questions. They didn't. So she did not abandon her job. She did not quit her job. And when they refused to take her back, that's a termination. And potentially, it's also a human rights violation. So I want our viewers to understand that if you're sick, it doesn't have to be cancer. It could be anything. But if you're sick under doctor's care, you can be off work while still maintaining your employment status for as long as it takes usually. It could be sometimes months. It could even be years. So in most cases, if that happens and you're off work, the company has to take you back. If they don't take you back, that's a termination. It's not a resignation. It could be a human rights violation. So the good news for this lady is, despite the fact that she's not going to get her job back, she could be owed easily 2 years' pay. So I'm going to work with her to make sure that she gets it.
Another angle with that is, I know a lot, this comes across your desk all the time, and also with Savan, your partner, who does the injury law as well. Sometimes when people are off on a medical leave, they may be on disability, and they may be getting paid by an insurer, and eventually they get cut off. Now, the employer sometimes thinks, well, if they cut you off, now you have to come back to work. Those two things are separate.
They're completely separate. So you may have been cut off by the insurance company. By the way, the insurance company may be wrong in cutting you off. They may not be allowed to do that. So we can certainly help people that have been cut off. But even if the insurance company is somehow correct, as long as you have a doctor saying that you cannot work, the company cannot make you come back. They cannot penalize you. They can't say, well, the insurance company cut you off, so you have to come back. Those are separate things. Being away from work and qualifying for disability leave are separate things. And if the company wants you to come back before you're ready, you don't have to. If they punish you, if they let you go because of that, you call me, because that's illegal.
And these are very private matters. And in that regard, you've often said your employer is allowed to know prognosis, not diagnosis. Two different things, right?
Absolutely. Most employees are not going to want to tell their employer what their specific medical condition is. And you don't have to. The employer is allowed to know prognosis. In other words, how long will it be before you get back to work? What kind of limitations will you have? Not diagnosis, not what your medical condition is, what your treatment is, what doctor you're seeing. Those are private things. You don't have to provide that to your employer, and your employer should not ask for those things.
1-855-821-5900, by the way. Anytime you want to get a hold of Lior, make that phone call, or help@employmentlawyer.ca is a good way to email us. If you want to go to employmenthourtv.ca as well, you will find there on that website where you can find our 1-hour radio show, The Employment Hour. And on the radio show, of course, we talk about matters just like this. We take a ton of phone calls as well. And some of the people want to have their phone calls played because it's important stuff, and we feel the same. So every week here in the show, we like to play a few phone calls and get you to comment on it. So we'll get to one right now.
This week, they actually put out packages for voluntary retirement, which I received. But when I look at it, it's not that great. I'll be there 19 years in July. I'm an analyst. I am 58.
So here's the thing. If the company is not terminating, if they're saying, hey, you can continue working, no problem, but if you want to, we're going to offer you this package to leave, only if you want to. In that situation, the law really doesn't intervene, right? Because the law only intervenes when the company lets you go and then makes the company pay you severance. But in this situation, if they're giving her an option, it's up to her to decide whether that option is attractive to her, whether she wants to take it and leave. Now, in doing that, she'd have to assess that in reference to a severance package. So in other words, if what they're offering her to leave is half what her severance would be, it's not a good deal. If it's 98.5% of it, for example, then it is a good deal. So what would this lady be owed? So what I've done is I've taken her information and I put that in the severance calculator, severancepaycalculator.com. We'll talk about that in a second. Yep. And here's what it tells us. She's an analyst. She's been there for 19 years. She's 58 years old. Well, Severance Calculator correctly assesses she'd be owed anywhere from 18 to 24 months severance. So that's what she's owed, and anyone can find that out about for themselves on severancepaycalculator.com. So as a voluntary package, if they're saying they're offering her 8 months pay, that's a third of what she's actually owed. Not a good deal. Right. So you always want to start off by understanding how much you're actually owed. And if it's not something if they're offering you something that doesn't make sense as a voluntary package, just say no, continue working, and at some point they may want to terminate, in which case you'd get your full severance.
Now, this voluntary package, would this, like normal severance, include all components of her severance, or car allowance if she has one, or bonus, or all that stuff?
So here's the thing. If it's a voluntary package, that company can decide to do whatever it wants. They could offer to pay you in rocks. I mean, if you say yes, then that's the deal. When it comes to actual severance, when the company lets you go, then the company has to include all components of your compensation: salary, bonus, benefits, car allowance, pension, etc., etc., etc. So you have to keep that in mind when you assess whether your offer is adequate or not.
EmploymentHourTV.ca is where you want to go if you want to catch one of our radio shows that play throughout the week and the weekends here. Want to get to another phone call? We'll play another phone call from the show, and I'll have you comment on that as well.
Is there a difference in severance package if you're a manager or in management as opposed to like hourly paid worker?
Yeah, pretty common call.
A very common question. So remember, the factors that go into assessing severance are your age, the length of your employment, and the type of job that you have. So yes, the type of job is going to impact severance. A manager is going to be owed more severance than a non-manager generally, okay? All things being equal. So a 40-year-old manager with 2 years of service is going to get more severance than a 40-year-old non-manager with 2 years of service. But remember, the fact that a manager may get more severance doesn't mean that someone that's not a manager doesn't get severance. In fact, they do, and in fact, it could be substantial, and it's much more than a week's pay per year of service. So you call me, you go to severancepaycalculator.com to find out exactly what you're owed.
And that qualifies for part-time too. Part-time people get severance a lot. Don't
part-time, full-time, young and old, everyone gets severance.
Help@employmentlawyer.ca is the email to get a hold of Lior anytime, 1-855-821-5900. Now, one of the topics I want to get to on this show, a lot of it is by request. A lot of people want to know these things because they email, they talk all the time, they call you. So we're going to get to it. 5 reasons why people accept bad severance offers. So I'll start on these, and I know you're going to comment on each one. Number 1 is the employer alleged that the employee was terminated for cause.
For cause. So, John, there's several reasons, and we're going to talk about the main ones as to why people accept inadequate severance. And that's a huge problem because in my experience, and I've been doing this for a long time, over 90% of people accept inadequate severance. So we want to talk about why that happens so that if you're watching us right now, you keep those things in mind and you don't let that happen to you. I don't want you to be one of the 90%. I want you to be one of the 10% that actually gets what they're owed if they lose their job. Right. So one of the reasons, as you've said, why people accept inadequate severance is because the company let them go for cause, and the person may think, well, I did something wrong, so I should take whatever they're offering me.
Company knows best.
Company knows best. And yeah, I don't have clean hands. I did something wrong. But here's the thing, John. It's extremely difficult to establish cause. You may have done something wrong. That does not mean that the company has cause. Cause is reserved for the worst offenders. And there's no such thing as almost cause. Either it's there 100% or it's not there at all. Right. So in most cases, when the company lets someone go for cause, they really don't have cause, and that means that the person is owed their full severance. So I may say, okay, I was late twice this week. They fired me for cause. They're offering me $2,000 in severance. I should take it because I did something wrong, not knowing that because that's not cause, I could be owed $20,000 in severance. So if you're let go for cause, understand that it's very difficult to establish. You have to understand what you're owed, and don't assume that just because you did something wrong, you don't get severance. That's wrong.
The 5 reasons why people accept bad severance offers. Another one is the employer used an offer deadline as a pressure tactic. Friday at 5, have it back to me.
So I lost my job. The company says, we're going to offer you the severance, but only if you sign this by Friday. Right. I'm going to panic, and I'm going to think, I need this money because I lost my job, and I'm going to sign this offer. Not understanding that my legal rights don't expire Friday at 5, Tuesday at 3, or whatever the deadline is. I have 2 years to pursue those entitlements. That deadline, John, is a pressure tactic. That's all it is. Yeah. It's there to make the employee feel that they're going to lose something if they don't sign. Don't let that happen to you. That deadline is not important. It's meaningless. You're owed what you're owed. And if the law says you should have another $50,000 over and above what the company's offering you, then that's what you should have. It doesn't matter what that deadline is. Don't be intimidated. Call me and let's discuss.
1-855-821-5900, by the way, anytime to get a hold of Lior, a member of his team. We're talking about the reasons why people accept bad severance. This one's a beauty as well. The employee believes, and quite often the employer as well, that they can't afford to take any legal action against them.
Well, the employee may say, yeah, I may be owed more severance, but I can't afford a lawyer. I'm afraid of the legal process. It's going to take a long time. Well, John, every case is different, but I can tell you generally that the legal process when it comes to severance is straightforward. It's not long, it's not expensive, it's not complicated. Other legal matters, it can be. But not when it comes to employment law. Usually these matters resolve within a few days, a few weeks. In many cases, they resolve often without formal legal action. And in most cases, legal fees are either nominal or the company pays for it. So people that accept inadequate offers because they think they can afford to get what they're owed are wrong, and they're losing out on money that the law says they should have. So don't let that happen to you.
Email, by the way, is help@employmentlawyer.ca. We are getting through our list of the top 5 things and reasons why people accept bad severance. Another one is the employer tried to negotiate the package on themselves. I mean, it can happen, but it's not advisable.
Yeah, well, it's not likely to be successful.
Yeah.
So an employee tried to negotiate. The company didn't negotiate, so the employee thinks, well, I tried, I can't negotiate, so I have to accept. Well, the reality is, John, if you're trying to negotiate yourself, you're telling your employer you're not serious. You're telling your employer you're not really willing to do something about it. And in many cases, John, the employer itself may not realize what they owe you. They need to be educated. So people accept inadequate severance because they've tried to negotiate and they haven't been successful. Nonsense. Don't let that happen to you. It's my job to negotiate these severance packages. I do that for a living and I do it very well. And let me do my job. Let my team do our job. And don't accept anything because you assume that you cannot improve it. I almost promise you that's wrong.
Plus, I mean, generally speaking, especially with the companies that are larger in size, they expect you. They're hoping not. They don't count on you doing it, but they're expecting you to go see some legal advice and come back to them.
Yes.
Not accept it. So do it.
Well, they understand. If I let go 10 people and I'm going to give all of them inadequate severance packages, I expect that 1 or 2 of them maybe are going to come back and I'm going to have to pay them what they're actually owed. Okay, so make sure you're one of those people because you don't want to be the 8 or 9 that accept inadequate severance because once you've signed it, once you've accepted it, you're stuck. You can't go back. You can't get out of it. You can't say that I signed it under pressure. You're done.
I want to get to one more of these, the top reasons why people accept bad severance offers. The employer this time didn't realize that the employee is entitled to more or relied on, dun, 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 the Ministry of Labor.
Yeah. So
Good move.
Either the employer didn't know what the employees owed, or the employer was hoping that the employee didn't know. There's a lot of misconceptions. So mostly, for me, the idea of accepting an inadequate severance package comes down to lack of knowledge, lack of information. People will believe that they're owed a week's pay per year of service. People will believe that they can get the right advice from the Ministry of Labor, and the Ministry of Labor gives them the incorrect advice, which happens all the time. We've talked about this on the show many times. So what we're trying to do here is arm people with that knowledge. So now there's no excuse. Now you can never say, I didn't know. Now you know, because you've listened to our show. So yes, people accept inadequate severance package because they don't know any better. Employers and employees, you know better, so that should be the end of that.
Any of these 5 points, you want to get more information on them, just simply call Lior and a member of his team, 1-855-821-5900, and help@employmentlawyer.ca as well. We'll take a short break. I want to get into the severance pay calculator and what happens when you clash with the new boss. That's all on the way on Employment Hour in 30. Hang on.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact, the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first.
Hey, welcome back to Employment Hour in 30. This is the part we really love, where we talk about a tool that is invaluable to you, all of us as employers and employees for that matter. It is SeverancePayCalculator.com. Give me the dirt. How does it work?
The dirt.
That's
okay.
right.
Well, SeverancePayCalculator.com, really the whole idea behind informing people came down to the fact that I saw people accept inadequate severance, as we were talking about before the break, and I wanted to do something about that. And one of the easiest ways that I could think to do something about it is to give people access to the information so that anyone and everyone can find out exactly what they're owed. So SeverancePayCalculator.com is the website I created. Again, SeverancePayCalculator.com. It allows anyone to find out exactly how much they're owed if they lost their job, if they're worried about losing their job, or maybe they're just curious. I'd like to know, hey, maybe they would let me go at some point. What would I be owed? You go to SeverancePayCalculator.com, you answer 3 questions about your age, your position, and the length of your employment, and you find out what that severance number actually is for you. Or, by the way, if your friend was let go and you want to help them out,
sure,
again, tell them to go there, or you can go there on their behalf. It's easy. It's free. There's no strings attached. You don't have to put in your name or the company's name. You don't have to put in a credit card number. Nothing. I just want you to have that information. Check it out right now. It's not a week's pay per year of service. It's not even close. It's a heck of a lot more than that. SeverancePayCalculator.com.
Now, over 500,000 people have used this and tried it out because they need it, or they're just for interest's sake. I know a lot of people are going to go through this and say, whoa, 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 whoa. This number is so much larger than what's on my severance offer. There's got to be a bug in the calculator. This can't possibly be true.
Well, that's why I created it. If people knew that information, if people appreciated what that is, there would be no need for it. People still assume that it's a week's pay, maybe 2 weeks pay per year of service. It's not. For some people, it could be several months pay per year of service. For some people, the length of severance could be more than the length of employment.
Right.
So there's no bug in the system. If you want to know what you're owed, go to SeverancePayCalculator.com.
And there is also an employer mode as well. If you want to find out, if you want to do the right thing and pay an employee that you're about to let to go, what money they need, you go to SeverancePayCalculator.com as well. And a contact button at the bottom if you want to get a hold of Lior. If not, you walk away completely anonymous. Want to get to an example of the calculator that we got in here, and I'll let you talk about it and expand about it after that. It says, after 8 years of hard work, Francois was let go. His boss said that his performance had slipped over the past month, which was news to Francois. He was offered 8 weeks of severance pay. Is that a fair amount?
Well, let's start with the idea that his performance has supposedly deteriorated. Let's take that at face value. Let's assume that was the case. I understand Francois disagrees, but even if that was the case, that does not mean he can be let go with less severance or reduced severance. He's still owed his full severance, unless he did something as bad as stealing or hitting someone or threatening someone. Right. He gets his full severance. So what does he get? Well, anyone can find out. So let's plug his information to severancepaycalculator.com. So he's in a technical role, 8 years of service. I picked age, let's say he's in his 40s. Well, someone in his situation is owed 9 to 12 months of pay. Now, they offered him 8 weeks, depending on his compensation, whatever the number, the difference is, but it's going to be in the tens of thousands of dollars. So instead of 8 weeks, 9 to 12 months pay. So what you're seeing on the screen right now is what you can find out for yourself if you go to severancepaycalculator.com. It's that easy, it's that quick. And now Francois, if he uses that, he would know to say to the 8 weeks, thanks, but no thanks. I'm owed 9, 10, 11, 12 months pay. You can take your 8 weeks and give me what I'm actually owed.
Again, severancepaycalculator.com. Anytime there's a contact at the bottom. Phone number works as well, 1-855-821-5900 to get a hold of Lior and a member of the team. Phone calls as well. We take a ton on our weekly radio show, and if you want to check it out, simply go to employmenthourtv.ca, and there's a place for you to find out, to dial in, tune in, and listen to the shows. They're an hour long. They happen several times during the week. We take a ton of phone calls from people like you who are interested and want answers. So we'll get to a phone call, and I know you want to comment on it, Lior.
I work for a public company here, and I'm partly sales involved, and they've hired a new gentleman who's going to be taking over the old boss, who's soon to retire, and he's been really grinding me around. I don't want to really quit because I know there won't be a severance package, and I also don't want to get fired for going back at him and responding to him in a negative way. I was wondering, what options do I have?
What do you think?
Well, John, obviously, sometimes when you get a new boss, you had maybe a good relationship with the old boss. The new boss wants to do things differently. Maybe you don't get along, and this conflict often happens. Well, here's the thing. First of all, if the boss mistreats you, I want you to document that. Okay, I want you to have a journal, a log, somewhere we can document what actually happened, because at some point, this mistreatment, this poison work environment could be a constructive dismissal, which means you can leave there with severance, okay? If you're being mistreated by your boss, that's not something that the boss is allowed to do, and you have rights. Now, beyond that, he says he doesn't want to confront his boss because he's afraid he's going to lose severance. So what I would do, instead of going to the boss and saying, hey, boss, you're unreasonable and you're an idiot and whatever it is, not a good idea, put it in writing. That way you can control what is said, and the boss can't say you called me an idiot, because no, it's in writing. So tell the boss what your concerns are. I'm concerned that you're not treating me properly. I'm concerned you're being unreasonable. I'm concerned that you're giving me jobs that are not good. Whatever it is the problem, put that in writing. Because if you do that and the company decides to let you go, you will get your full severance. The concern I always have is the boss says, no, you came and you were disrespectful and you insulted me and threatened me, so I have cause to let you go. If you put that in writing, that's not an issue. So it's okay to confront your boss for something wrong that they did. Just do it in writing, be respectful, you can be direct, and if you do that, you're not going to lose your severance. You're not going to be at risk. And remember this idea of constructive dismissal. You shouldn't have to tolerate harassment, mistreatment at work. If that happens to you, you have rights. Call me.
1-855-821-5900 is that number. help@employmentlawyer.ca as well. That is through email. We'll take a short break. When we come back, we're going to talk about false for cause terminations and severance for contractors as well. There is such a thing. That's coming up on Employment Hour in 30.
Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact, in most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
And welcome back to Employment Hour in 30. Lots more to go here for this week. If you want to contact Lior, 1-855-821-5900 and help@employmentlawyer.ca as well. We also do radio shows. They're an hour long. We've been doing them for over 5 years now. We've been around a while, son. And we take a ton of phone calls on these radio shows. We play them back here with the permission, of course, of the people who called in with their questions and their queries. And we'd like to get some feedback on them. So we'll get to another call.
I was terminated from my job on October 30th of last year, and without warning. I was accused of destroying property, which I had no knowledge of, so I'm wondering what kind of recourse I might have. I worked there 6.5 years, logistics manager.
Well, obviously, John, if he destroyed property, then that's a problem. Yep. That could be cause, despite what I said earlier about cause being very difficult to establish. Yep. If you destroy purposely someone's property, your boss, the company's property, that's a problem. And that could be criminal offense, but it could also be cause for dismissal. But this person says, never happened. Well, guess what? The onus, the burden of proof is on the company. They have to prove that he did it. Speculation, rumors, innuendo is not good enough. They have to prove that he did it. If they can, okay. If they cannot, then this is a wrongful dismissal. He is owed severance. So if he says he didn't do it, the company can't prove that he did, then they have to pay him a severance. So the question then becomes, what is severance for him? So I took that information, I plugged it into the Severance Pay Calculator just so that everyone can see that information. So let's look what that gives us. So he's a manager, he said a logistics manager, 6.5 years of service. I guessed, let's say he's in his 60s. Mm-hmm. Well, as you can see on the screen right now, Severance Calculator correctly assesses him as being owed 8 to 10 months of pay. Wow. So they gave him nothing because they say they have cause because he destroyed property. If he did not do it, if the company can't prove it, as the severance calculator shows, anywhere from 8 to 10 months of compensation that he's owed. Now, I don't know how much he's making. Maybe he's making $30,000. Maybe he's making $130,000. Either way, 8 months' pay is a lot of money. So that's what's at stake. That's a wrongful dismissal. And I want our viewers to understand that if you've been accused of something and you didn't do it, it's wrong. The company can't prove that you did. You've been let go because of it. That's probably a wrongful dismissal. You're owed compensation. Call me or go to the Severance Pay Calculator.
SeverancePayCalculator.com, by the way, and 1-855-821-5900 to get a hold of Lior. There's also another resource for you as well to ask questions when we're not doing the radio show, not here on the TV, and that is terminationquestions.com is there as well. You can simply add a question in there, and it'll be answered by Lior, member of his team. For instance, I'll get to one that came across that website a short time ago. It says, just days after I submitted a request to the company for my performance-based bonus, I was fired for no reason whatsoever. They said that because I was an independent contractor, here we go, they don't have to pay me. Is that true?
Well, first of all, let's talk about the bonus. Yep. If he usually gets a bonus and then all of a sudden the company decided that they don't want to do it, they can't do that. They have to pay a bonus if that's a term of employment. I always get a bonus. Now you don't want to pay me. You have to pay me, and your refusal could be a constructive dismissal. If they never paid him a bonus, but he thought this year he should get one because he did an extra bang-up job, yep. Okay, the company doesn't have to pay it even though he did a good job. But what they have to do is they have to pay him severance. So if he says, or the company says he's an independent contractor, well, if he's been there for a number of years, if he's getting compensated as an employee, he is, in the eyes of the law, an employee. So this idea of calling someone an independent contractor is meaningless. If you look like an employee and act like an employee, it doesn't matter what you call yourself, you're an employee. So he would be owed severance in that situation. If he's really an independent contractor, if he's his business for himself, he has clients all over, he has people working for him, then he is an independent contractor and he would not be owed severance. That's probably not the case. We have a lot of people watching us right now who probably believe that they're an independent contractor. Maybe they get taxed as an independent contractor. Maybe they even sign a document saying that they're an independent contractor. Well, John, none of that matters. It doesn't matter how you get taxed. It doesn't matter what you sign. If you look like an employee, if you act like an employee, in other words, if you have a regular job, you go to work, you get paid, you come home and repeat the next day, you're an employee, you're owed severance, you potentially are owed other things, overtime, vacation pay. So remember that what you call yourself is ultimately meaningless.
I'll ask you this just before we wrap up for this morning. If he does qualify for that bonus and because of history, if they let him go a month, 2 months, maybe strategically before he's supposed to get that bonus, does he still get it?
The company cannot pick a convenient termination date to avoid paying money that the employee actually earned. So if you've earned a bonus, you got to get paid the bonus. Not only that, if the company tries to kind of get away with letting you go right before, they could be punished. They could be having to pay what we call bad faith damages by trying to effectively screw over an employee. You cannot do that. That's wrong. So if the company does that, you have rights.
Again, terminationquestions.com to ask those questions. If you have used it before, SeverancePayCalculator.com. That is where you want to go. go first to find out exactly how much severance you're owed. Email as well. You can do that, help@employmentlawyer.ca, and there's always the old phone call, 1-855-821-5900. Till next time, this has been the Employment Hour in 30.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.